What I have for you today is the final decision in a case we've discussed before in the Danish beneficial ownership saga. I will put a link to the previous discussion on Takeda below the description of this case. So the case has gone from the Danish High Court to the European Court of Justice, and from there to the Danish Supreme Court, and this is the decision that we're looking at now. So let us go in and see what the decision has been. Just a reminder for everyone, it was quite a complicated structure, but what basically happened here was you had Nycomed AS, that is the Danish stop holding. It was later acquired by a Japanese group called Takeda, and it was renamed Takeda. It is currently in liquidation, and it was transferred to Nycomed Swedish Holding 2, which was held by Nycomed Swedish Holding 1, which was held by Nycomed SCA Sikar, which was a Luxembourg investment company. And basically this Luxembourg investment company, even though in name it was subject to tax, did not pay tax on interest that it received. Nycomed SCA Sikar lent 500 million euros to Sweden Holding 1, which then contributed the 500 million to Sweden Holding 2, which then lent the money again to Nycomed AS. And what that meant was that the Danish company was paying interest to the Swedish company. Now, the holding company 2 would have been subject to tax on that interest income because it was financed with equity, but under Swedish rules, it could transfer its profits to Holding 1. And Holding 1 had huge interest costs because it owed 500 million to the Luxembourg Sikar. And so the income from Holding 2 was offset against the interest cost of Holding 1. So there was no tax in Sweden and there was no tax in Luxembourg, which meant that you end up with a tax deduction in Denmark only. And the Danish tax authorities said that none of the companies above were beneficial owners of the interest, and therefore the interest and royalty directive under EU law did not apply, and none of the treaties applied because again these companies were not beneficial owners. And the court went from the case went from the Danish High Court to the Court of Justice of the EU because it involved the interpretation of the interest and royalty directive, whether the conditions of the interest and royalty directive were satisfied. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. Or not. Now, if we look at the interest and royalty directive, then first, as regards the scope and procedure of it, it says interest and royalty payments arising in a member state shall be exempt from any taxes imposed on those payments in that state, whether by deduction at source or by assessment. So in any way it's exempt, provided that the beneficial owner of the interest is in another member state, right? But it must be the beneficial owner. And then paragraph 4 says a company of a member state shall be treated as a beneficial owner of the interest or the royalties only if it receives those payments for its own benefits and not as an intermediary, such as an agent, trustee, authorized signatory, or some other person, for some other person, right? And then it also defines what a company is, and the definition of a company is important because the question ultimately was whether the Luxembourg Sikar was qualifying for the interest and royalty directive benefits. And one of the conditions of being a company under the interest royalty directive is that you must be subject to tax. So Article 3, paragraph 1 says, for the purpose of the directive, the term company of a member state means any company which, it's got 3 conditions, but the third one is which is subject to one of the following taxes without being exempt. And then for Luxembourg, it was the impôt sur les revenus des collectifs in Luxembourg. And we'll see what the Court of Justice said about that. The other 2 conditions was that it was resident in a member state and it wasn't resident in another state, issues like that. But it was especially this third condition that was important. And then finally, Article 5 of the Interest and Royalty Directive deals with fraud and abuse, and it says this directive shall not preclude the application of domestic or agreement-based provisions required for the prevention of fraud or abuse. And more important, the second paragraph, member states may, in the case of transactions for which the principal motive or one of the principal motives is tax evasion, tax avoidance, or abuse, withdraw the benefits of this directive or refuse to apply the directive, right? So the Danish authorities said this is an abusive transaction. We will not give you the benefits of the Interest and Royalty Directive. And by the way, you do not qualify for any of the treaty benefits because, again, you are not the beneficial owner and this is treaty abuse. So let's see what the Court of Justice said in its decision under the Interest and Royalty Directive, because this is very much what goes into this case as it deals with the question of beneficial ownership, right? So the on beneficial ownership itself, the CJU says the concept of beneficial owner of the interest within the meaning of Directive 2003/49, so Interest and Royalty Directive, must therefore be interpreted as designating an entity which actually benefits from the interest that is paid to it, right? So it's not just a name you receive, but you are the actual receiver. The use of those various expressions underscores, and this is different translations of beneficial ownership in the various versions of the directive under the languages of the different member states, that the term beneficial owner concerns not only a formally identified recipient, but rather the entity which benefits economically from the interest received and accordingly has the power to freely determine the use to which the interest is put, right? So you must be able to use it actually. And then it also says, you know, and the beneficial ownership, if you look at the history of the Interest and Royalty Directive, it actually looks at the treaties, the OECD Model Convention and the commentaries to it, and that's where the concept comes from. And then the Court of Justice said it is clear from the development of the OECD Model Convention and commentaries relating thereto that the concept of beneficial owner excludes conduit companies, and there's also the conduit company reports from the OECD, right? And must be understood not in a narrow technical sense, but as having a meaning that enables double taxation to be avoided and tax avoidance and tax evasion to be prevented. Now the conduit company report was a little more nuanced, I think, than what the Court of Justice would like to say here. And of course, the Court of Justice interprets the OECD Model Convention blindly following the commentaries without really going into the meaning of Article 3.2 on looking at national legislation. Now, the part of the problem in this case was that Denmark didn't have national legislation dealing with beneficial ownership at that time. And it also doesn't look at the relationship between the commentaries or the hierarchy between the commentaries and the Vienna Convention on the Law of Treaties, which is, I believe, still in some academic circles a hotly debated topic for those people who do not know how a treaty is actually concluded. And then we come to whether this transaction was an abuse of rights, and the Court of Justice says examination of a set of facts is needed to establish whether the constituent elements of an abusive practice is present. And what I like about the Court of Justice decision here is it describes different indicators of when a transaction is abusive, right? And it says a group of companies may be regarded as being an artificial arrangement where it is not set up for reasons that reflect economic reality. Its structure is purely one of form, and one of its principal objectives is to obtain a tax advantage running counter to the aim and purpose of the applicable tax law. That is so inter alia where payment of the tax on interest is avoided. So you get the deduction, but you don't get the payment of the income, tax on the income, right? Likewise, the artificiality of an arrangement is capable of being borne out by the fact that the relevant group of companies is structured in such a way that the company which receives the interest paid by the debtor company must itself pass that interest on to a third company which do not fulfill the conditions of the directive. So again, a definition of a conduit for actually, right? Legally you are the owner, but if you look at it economically, you cannot do anything but the interest because you need to use it almost immediately to pay someone else, and whoever you pay does not qualify for the benefits of the directive. The fact that a company acts as a conduit company may be established where its sole activity is the receipt of interest and its transmission to the beneficial owner or to other conduit companies. Another indicator. And then finally, such indicators may be reinforced by the simultaneity or closeness in time of the entry into force of major new tax legislation, such as the case in Denmark when they introduced the withholding taxes on interest going out in these particular cases, which some of the groups of companies strive to circumvent, and the setting up of the complex financial structure, such as we saw Takeda has had, right, with quite a number of companies and arrangements in between. And then the question was whether a CCAR, such as the Takeda CCAR in Luxembourg, qualifies for the Interest and Royalty Directive, and the Court of Justice also talked about this, and it said that as regards the third conditions, it is not disputed that XCA CCAR is subject to impôt sur les revenus des collectifs, a corporate tax in Luxembourg, which is one of the taxes listed in Article 3A. In other words, so it was subject to tax as required by the directive. But then the Court of Justice said, however, should it have to be found that the interest received by SCA is in fact exempt in that respect from corporate tax in Luxembourg, it would then have to be stated that the company does not satisfy the third conditions, because what happened was, formally the CCAR is subject to tax, but the interest income that it received was exempt from taxation in Luxembourg. And that's what the Danish tax authorities said. They said, we don't need to apply the Interest and Royalty Directive because the CCAR is only formally subject to tax in Luxembourg, but not on the actual interest income. And the Court of Justice said that interpretation of the scope of the third condition is supported. First, they said by the fact that PEs are only the beneficial owners of income under the Interest Royalty Directive if they are subject to tax on that income, right? Which is a bit of a nonsense argument, because this is about profit allocation to PEs. It's not about beneficial ownership. But then, secondly, the court said in the third last line, and second, by the objective of Directive 2003/49, which is to ensure that such interest payments are subject to tax once in a single member state. And that obviously is a real reason, because ultimately the Interest and Royalty Directive wants to make sure that there's no double tax on interest received, and not that there's no single tax on interest received. And the Danish Supreme Court followed quite easily, obviously, the decision of the Court of Justice, and it said, were the Swedish companies the beneficial owners, or were they conduits? And the court says that the Court of Justice has ruled out on what elements constitute abuse, and we've just looked at those. But it's nevertheless for the referring courts to verify whether those elements are objective. So when you have abuse on national law, and whether taxpayers have had the opportunity to adduce counter evidence, right? And here comes an interesting case, because the court says the court assumes that the purpose of the reorganization of the group, as described in detail in the High Court's judgment, was to reduce Newcomet's taxable income in Denmark, right, with deductible interest expenses, which without offsetting interest income being taxed within the group. The Supreme Court finds that the restructuring must be seen as a comprehensive and pre-organized tax arrangement. And then the court says, for the reasons stated by the High Court, the Supreme Court finds that it cannot be assumed that Newcomet Sweden Holding 2 or 1 had the power to freely determine the use of the interest transferred from Newcomet, right? And the structure was set up quite cleverly, because it is not that Newcomet 2, which was the bottom company, paid interest to Newcomet 1. No, it surrendered its income under Swedish tax law only to Newcomet 1, which then used it to offset its interest cost to Luxembourg. But obviously, the Swedish top holding company could only pay that interest to the CCAR if it received a dividend from its Swedish subsidiary, which dividend came from the interest which was paid from the Danish company to the Swedish company, right? The Supreme Court finds that when assessing whether a company is to be considered the beneficial owner of the interest or a flow-through entity, it is irrelevant whether the interest have been effectively paid or whether the interest has been added to the principal of the loan. And part of what the taxpayer in this case said is, they said, no, but you don't understand. We never paid the interest. That interest was just accrued to the principal on the loan from Denmark to Sweden, and then again from the top Swedish company to the Luxembourg company. And the treaty talks about paid, right? And there has been discussion in the past about whether the withholding tax only becomes due upon payment of the interest or whether it becomes due when it is accrued. And here the court says, with regard to the interest and royalty directive, it's irrelevant whether it's paid or accrued. I mean, it is due, and therefore the tax is due as well. And so the court decides that the Swedish companies were not the beneficial owners, right? Because they were conduits. And then the question is whether the SICAR was a beneficial owner. And the question is then whether Takeda has established that Nycomet's SCA SICAR, or NSS as we call it here, is the beneficial owner. And the court comes with something interesting. The court says Takeda has not submitted the agreements entered into between NSS and the underlying private equity funds, because if you remember the picture right in the beginning, the Luxembourg company was owned by various private equity funds, right? And between the private equity funds and their shareholders and investors. So what the court wanted to know was, do these agreements say that the SICAR had to pay out the interest immediately, or could the SICAR use the interest that it received for other investments and stuff like that? Because if it could, then it would have been a beneficial owner maybe, but if it couldn't, then it wasn't a beneficial owner either, right? And the court said we asked for the documents, we never got them. The Supreme Court notes that the management shareholders agreement states that an investor shareholders agreement had been entered into. The latter agreement, which could possibly shed light on what was agreed between NSS and the underlying private equity funds, including the company's authorization to dispose of the interest, have not been disclosed, nor have the agreements been clarified in any other way. So I'm not quite sure what happened here, but apparently the court asked the taxpayer, give me the documents so I could see whether the SICAR could decide over the interest that it received. And apparently the taxpayer said, either those documents don't exist, or you can't have them, or we can't find them, or whatever. But the court is, I think, rightly very blunt in this respect. It simply says the Supreme Court then finds, if we ask the documents, you can't give them, that Takeda has not established that NSS had the power to freely determine the use of the interest that it received. Therefore, there's no basis for considering NSS as a beneficial owner of the interest. And we've seen in the Tetra Pak case previously discussed on this channel as well, that a taxpayer says, sorry, you can't get the data. And the court has no mercy with that. Then the taxpayer loses, right? And the same happened here. Of course, I don't know what the actual facts and circumstances are. I'm sure if you talk with a taxpayer, they would have some agreement, some argument which seems reasonable as to why they couldn't hand the documents over. But ultimately, I would live by the doctrine that if a court asks for the documents and they don't get it, the court is allowed to say whoever is not giving the documents has lost the case. And then Takeda tried a backup argument. They said, even if SICAR was not the beneficial owner, then some of its investors would have qualified either under the treaty or under relevant treaties. Let's say they were U.S. investors or whatever, and then the Danish-U.S. treaty would have applied, or they were European investors, and then there still would have been no interest withholding tax due if they were the beneficial owners. But again, the court is very blunt here. It says Takeda submits that the withholding tax liability should in any event be reduced in respect of shareholders number 39 and 41. Apparently these were big shareholders who are both direct shareholders in NSS. And the Supreme Court just says, as stated above, the agreements between the company's funds and shareholders and investors in question have not been clarified. And Takeda has not demonstrated that the said shareholders and investors in NSS are the beneficial owners of the annuities. And therefore, again, no beneficial ownership. And the final judgment of the court is against the background. The Supreme Court finds that the tax arrangement constitutes abuse. Nycomet Sweden's Holding 2 is therefore liable to tax on the interest that the company received from Nycomet AS, the Danish company, for 2007 through 9 under the Danish withholding tax rules. I hope you enjoyed this case. I think, considering the decision of the Court of Justice of the EU, the Danish Supreme Court case is not a surprise, but it wraps things up nicely. And the moral of the story, or the takeaway I would say, is if the court asks for documents, give it to them.